Texas Local Government Code, I'll start with that, says that if a county has a public library, the Commissioners Court must employ a county librarian, and that the general supervision of the county library is under the Commissioners Court. And by general supervision, we're talking about hiring staff and setting a budget, allowing a place for the library to exist. In addition, the state librarian advises the librarian and the county court, Commissioners Court about the library. Excuse me. The county librarian under the Texas Government Code must, and of course in the law we pay special attention to must and shall, those are important words, must manage the library with accepted rules of library management. Those rules of library management come from professional organizations such as American Library Association. The county librarian shall determine which books and equipment will be purchased, and then may make rules for the day-to-day operation of the county library. And again, that comes from the Texas Local Government Code. I'm going to move to the Constitution. The U.S. Constitution and the Texas Constitutions both protect the fundamental right of adults and children to receive information. And in an important case, in fact, the only case involving censorship of public library books is Sund versus City of Wichita Falls. The court said, and I quote, "The right to receive information is vigorously enforced in the context of a public library." And I'll tell you that the majority of cases that are out there on censorship of library books involve school libraries. And school libraries have a wide discretion in the books that they put in their libraries, and narrow exceptions to books that they can take out of their libraries or censor. But public libraries even have a greater responsibility to the public to make sure that they are inclusive of books that are in their collections. From the United States versus American Library Association 2003 case, public library staffs necessarily consider content in making collection decisions, and they enjoy broad discretion in making them. And I'll move on to censorship. There's a lot of words that have been used to describe changing or removing books once they've arrived at the public library. And the case law says that censorship is all three of these things. Removing books, that would be taking books completely out of the collection, relocating books to a different place in a collection, or restricting access to books. And by that, the cases have shown, and again, these are mostly in the cases of school libraries, where school boards have asked students to get parental permission, written permission to access books. All of those are forms of censorship, and all of those will fall under the following guidelines. A public library is a limited public forum, and those words are very important in the context of constitutional law. Once you have a limited public forum, the county or the government's ability to restrict library patrons' rights of access to materials is extremely narrow. And I put those words in italics because that is very important, extremely narrow. If you'll move on. The county cannot limit access to library materials solely on the basis of the content of those materials. And in order to restrict any kind of access or relocate or remove books, the county must have a compelling government interest. Again, those are words that are extremely important in constitutional law. Next slide. Compelling government interest. In order to meet the compelling government interest, the materials have to either meet the stringent test for obscenity, or they have to be material harmful to minors. The description or the explanation of material harmful to minors has been, again, obscenity, pornographic, sexually explicit materials. That's what the courts mean by material harmful to minors. Has to be patently offensive, utterly redeeming, utterly without any redeeming social value. Has to appeal to the prurient interest in sex, nudity, or excretion. Those are the definitions. A government that votes to restrict access to any library books in the public library cannot be based on suppression of ideas, politics, religion, nationalism, or viewpoint. And then the last slide. There has to be a policy in place for challenging library books, which we have. The policy has to allow citizens with opposing viewpoints to speak publicly for and against a challenge, and our policy does follow those guidelines. And then I've concluded with 2 slides of the references that I used to make this opinion. And if you have any questions, I'll be happy to answer them.
Lori, I believe, and you referenced the Sun versus the City of Wichita Falls. Some of these exact books were covered in that case.
Yes.
And so the City of Wichita Falls did not, I guess, make the case that these were harmful to children. Is that right?
Right. There was actually a couple of issues in the Sund case. One of them is that the City Council had passed a law saying that if 300 library patrons objected to a particular book, they could have it removed from the library or relocated. And so that was primarily what it was about. However, the court did go on to say that those particular books that were at issue in Sund did not meet that strict compelling government interest for censorship. And that was a case out of the Northern District of Texas, which does control Hood County as well. Anything else?
Anyone else have any questions?
That case is still good law. It was a 2000 case, but it is still valid. Anything else?
Okay, because I believe that one organization said it wasn't, right?
I would respectfully disagree. Thank you.
Thank you.